The broadcast is now starting. All attendees are in listen-only mode.
Hi everyone, and welcome to our webinar this afternoon. We're after lunch now. So my name's Carly, I'm from Community Legal Centres Queensland, and here with me today we have the Queensland Police Service. So firstly, before we introduce our speakers, I'll just check that everyone can hear me. So if you can, on your GoToWebinar control panel, just press the button that looks like a hand and we'll see the hands go up at our end, and then we'll know that you can hear. So I can see some hands are coming up, which is fabulous. If you do have any issues throughout the webinar, please do let us know just through GoToWebinar or by sending me an email. I'll just pop your hands down now that we know that's working. So the topic for today's webinar is the recent amendments to the DV legislation in Queensland and the role of the Queensland Police Service High Risk Teams. So a really exciting topic and something that I think is relevant for many of our CLC workers. So before we get cracking, I'll acknowledge the traditional owners of the land on which we're holding this webinar today. In Brisbane, they are the Turrbal and the Yagara people. I wish to pay my respects to their elders, past, present and emerging, and acknowledge the important role that Aboriginal and Torres Strait Islanders continue to play in our society. As this webinar is being viewed by people throughout the state and probably throughout the country, I'd also like to pay my respects to the traditional owners of the land throughout Australia. And also welcome all of the Aboriginal and Torres Strait Islander people tuning in today. So, as I mentioned, DV legislation, there's been a lot of recent changes that have come in, including the mutual recognition of DVOs throughout Australia, new offence of strangulation, information sharing between agencies and the police protection notice. A lot of that has come from the Not Now, Not Ever report recommendations, which many of you will be familiar with. So today we've got with us Senior Research Officer Christine Carney and Senior Sergeant Sean Francis from the Queensland Police Service. They'll each be delivering one PowerPoint, and I've uploaded both of the PowerPoints into the handout section of the GoToWebinar control panel, so you can download those from there. I also emailed out the link to the PowerPoints yesterday afternoon, but just note that there have been a couple of very small amendments, so I've got the latest versions now up on our website and in the handout section if you wanted to re-download those. We'll keep questions to the end of today's session. There are two ways you can ask questions. You can press the button that looks like a hand that you're all familiar with, or you can ask a question by typing your question into the box. And what we'll do is we'll deal with those questions at the end of the session because there is a lot of content to get through. So without further ado, I will hand over to Christine. I'm just going to check. There is one question that's come through already. I'll just make sure that's everything is okay. So I just want to double check because one person has said there's no sound. Can everyone hear me? You are muted, but we should hopefully be loud and clear. Yep. All right, so I think, sorry to the person who's experiencing some sound issues. This webinar will be recorded, so if you aren't able to hear or do experience any problems throughout the session, you can always come back and watch later, and that'll all be up online tomorrow. All right, so I'll pass now over to Christine, and I'll come back to you towards the end of the session. Thanks, everyone. Thanks, Christine.
Good afternoon, everyone, and welcome to today's session. Just before we start, a quick caveat that the information provided in the following presentation is not to be disseminated outside of its intended use. If you do wish to use any of the information that we discussed today, please contact the Domestic Family Violence and Vulnerable Persons Unit for approvals. So today I'll be just going through the high risk teams. So quick overview, So with the Not Now, Not Ever report that was provided to government in 2015, there was a number of recommendations made to do with integrated service responses and high-risk teams for domestic and family violence. So the high-risk team and integrated service response trials have been led by the Department of Communities, Child Safety and Disability Services. And on the slide that you see, the recommendations are the ones that relate to the high-risk teams. So the integrated service response is really the foundation for the high-risk team. So having an integrated service response provides a number of benefits and challenges for all of the agencies involved. The main benefit, of course, is to reduce secondary victimisation of domestic family violence victims having to retell their story continuously to different agencies. It also increases the focus on victim safety and also perpetrator accountability. Of course, the challenges with any multi-agency, network, you will have power imbalances between different agencies. Each agency has a different approach, and also the resources which each agency comes with can vary. So with the high-risk teams, they will be part of a review and evaluation, which was also outlined in the Not Now, Not Ever report. So the Office of Women, along with the Department of Communities, Child Safety and Disability Services, are the lead again for reviewing and evaluating the high-risk teams throughout Queensland. Central Queensland University are assisting with the evaluation. And then, of course, the individual agencies may also conduct internal evaluations to determine the impact of the high-risk teams on their specific agencies. So the high-risk teams were divided into 3 models. So we had the urban model, and they're currently located in Logan, Beenleigh, Ipswich and Brisbane. There's also the regional with outreach models in Mount Isa and Cairns, and then a discrete Indigenous community model in Cherbourg. So the purpose of these high-risk teams is to really assess and provide safety for victims and hold perpetrators to account for those domestic violence incidents that are at extreme risk of either lethality or serious harm. So the high-risk teams are not a critical incident response. They're also not designed to be a first response. Rather, if a victim is in danger, the police response will always be business as usual, so attending the scene, ensuring the safety of the victims and arresting the perpetrator if need be. So as part of the high-risk team, the Department of Communities, along with the Office of Women, developed a common risk assessment framework. So this framework involved not only a risk assessment, but also common language and understanding of the definitions and terms used within the high-risk teams. So the common risk assessment framework was developed through extensive literature reviews looking at international and national risk assessment tools, and also reviewing any relevant policies, legislation and procedures. The tool was then co-designed with key stakeholders such as QPS, Department of Justice and Attorney General, Probation and Parole. So the Common Risk Assessment Framework will be assessed as part of the evaluation. So at the moment it is in the action research stage. So it may be altered towards the end of the evaluation to ensure that it is fit for purpose. So with the Common Risk Assessment Framework, there are a number of factors that are included in there. So they look not only at victim risk, it also looks at the perpetrators. So within the Common Risk Assessment Framework, there are 3 different levels of assessing risk as well. So the first level is the standard agency response to assessing risk. So for police, for example, the frontline officer will attend after receiving a call for service. they will determine the level of risk at that time. Then when a high risk is identified through that initial consultation with the victim, a second risk assessment is conducted using the framework. And then if a high risk is identified, it will be referred into the high risk team. For cases that aren't deemed to be high risk, they will be dealt with within the integrated service response. So with the integrated service response as well, that's also comprised of a lot of different agencies, including government, non-government organisations. Generally, you'll have a lot of the DV services involved, as well as courts, corrections, child safety, Queensland Health, for example, QPS. And the idea of the integrated service response is to ensure there are support systems in place before a domestic violence incident gets to the high risk stage. And then the high risk teams themselves, once they identify a high risk, then they'll work within a multi-agency group again to provide ongoing protection for the victim. So with the introduction of the high risk teams, there was the need to also increase the legislative arrangements around information sharing. So particularly because the high risk teams are multi-agency, including government, non-government agencies, there was a need to ensure that information sharing protocols were in place. So with the Domestic and Violence Protection Act 2012, amendments came into effect on the 31st of May, which ensured information could be shared to assess whether there was a serious threat to life, health or safety of persons, respond to serious threats to life or safety, refer people who fear or experience DV, and also outlined prescribed entities as opposed to specialist DFEC, service providers, because there's a different level of information sharing that's permitted depending on which agency it is. There was also a information sharing guideline which was drawn up by the Department of Communities, as well as the Queensland Domestic and Family Violence Common Risk and Safety Framework. So the information sharing guidelines are available from the Department of Communities website. Unfortunately, at the moment, the risk and safety framework is not available for public dissemination because it is an ongoing research component of the high risk teams. So I wanted to briefly go through how the high risk teams operate. So I have provided a de-identified case study for you all. So if you have a look at the slides over the next few slides, we'll go through the case study just briefly. So what happens is the referring agency will identify that something is of high risk, and the agency will refer into the multi-agency high risk team. So with the case study, the QPS were the initial referring agency. So to have the case referred into the high risk team, the QPS first completed the level 2 risk assessment and framework. They had a look at what the general and other risk factors were of the perpetrator. So that includes things such as criminal history, whether on probation or parole, whether they have any other orders, whether there's any mental illness. They also look at where the perpetrator is currently living. Do they have supports in place, or is there any kind of substance abuse? The risk assessment also has a look at the victims and whether there's any children involved. So that could include, if the victim is pregnant, if there's any diagnosed mental illness, looking at life-generated risks. So whether, for example, they're underage or from, say, a cult community or an Indigenous community, and also whether there's been previous violence They'll also have a look at the escalation and severity, because that will be really important in terms of whether the case would be considered high risk. And of course, they'll also look at separation, so whether there has been or is an impending separation. Obviously, research has shown that separation is one of the most dangerous times for a victim when they're attempting to leave a domestic violence relationship. So that will also be a key factor. Once the agency has referred a case into the high-risk team, the other agencies involved will then send through requests for information. So what they'll do, for example, if Queensland Health has information that a victim had attended on numerous occasions to ER, but didn't want to go to police, so police didn't have any reference to previous incidents, Queensland Health might say, I have this information. Alternatively, QPS might send a request for information to Queensland Health and say, you know, we have this case, we believe it's high risk. Do you have any information of prior victimisation? So all the agencies will compile all of their information together, and then this will be used to assist in any safety management for the victim and also for the perpetrator. From the Queensland Police side of things, so we will also look at whether there's any recorded domestic family violence histories, and that will be for the current victim and any previous victims. It will also include not only intimate partner violence, but also if there's other family violence and any serious violence in general. Now, the Level 3 MARA, so MARA stands for the Multi-Agency Risk Assessment. This is completed when all of the agencies are sitting together at the table to discuss a case. So the Level 3 is designed to value add to the Level 2 risk assessment that is done initially, and it will also identify any actions that the agencies need to complete to ensure the victim is safe and also to hold that perpetrator to account. The Level 3 tool also has a look at perpetrator and victim generated risks and any other areas of concern that any agency may have. So with the Level 3, they might also seek assistance from another agency or an NGO, for example, DV Connect or WAVES. As part of the Level 3, a safety management plan is then developed, and this might include agencies having to do particular actions and then reporting back to the high-risk team to ensure those actions are implemented in a timely manner. So some of the actions may be, for example, to engage a perpetrator and try and get them to attend behavioural programs, or for housing, for example, to provide alternative accommodation for a victim or a perpetrator that needs to leave. So I've just got a summary of the case study that you have in the slides. That was mainly so you can do some reading in your own time. Obviously, there's a lot of information in there that we don't want to go through today, but that just gives you a brief overview of what the HRT do. And down the bottom, it also shows that the high-risk teams can be effective in ensuring victim safety and also holding perpetrators to account and change behaviours. So there's a few benefits for the QPS. Obviously, there would be a reduction in calls for service if we can prevent future offending and future victimisation, as well as cost effectiveness and in terms of not having to continually go out to the same people. There's also increased availability of staff to address other policing activities and responding to other crimes because, again, they're not attending the same locations. There's also increased accountability and tightened supervision for offenders. So I'll pass over now to Sean, and he will take you through all of the legislation.
Good afternoon. I'll be addressing the legislation in relation to strangulation, and that's section 315A of the Criminal Code. It was recommended by the Bryce report that a separate offence of strangulation be implemented. 50% of strangulation cases, even fatal ones, do not have any visible injuries. Death can occur from stroke or associated conditions within minutes, up to years. Sometimes it's about 4 to 5 months after the incident. We don't have a lot of data yet on post-strangulation injuries, but there's currently a research being done at the PA hospital to explore those sorts of injuries. Only 5% victims seek medical attention within 48 hours of a strangulation. Many victims seek to minimise the event, and memory loss surrounding the event is a key indicator of brain injury. So the Bryce report, like I said, recommended that there be a specific offence of strangulation, and there was extensive public consultation. There was opposition to the notion of a offence of strangulation, but at the end of the day, the government has enacted legislation, May 2016, of strangulation, suffocation, choking in a domestic setting under 315A. Now, strangulation in the Criminal Code, section 315, you have to prove beyond reasonable doubt that the strangulation occurred during the course of committing an indictable offence. Strangulation, DV strangulation, 315A, you only have to prove the elements of that the person is in a domestic relationship and that there was no permission or consent given for that choking, suffocation or strangulation. Part 2 is that the choking, suffocation or strangulation is associated domestic violence. Now, the legislation is clear that assault is not an element of the offence, and that then brings in the defence of provocation won't apply in the DV strangulation. To commence proceedings for the offence against section 315A, it's only necessary the prosecution be able to prove the elements of the offence and negate any defences that may be raised. At law, there is no precondition requiring a person to make a complaint to police. However, the absence of consent is an element that must be proven, and it will be difficult for the prosecution to prove the absence of the victim indicating they did not consent prior to being strangled, suffocated or choked. And so the investigators with the strangulation offence obviously have to negate that consent at the very bare minimum when they're getting a statement from the victim. The legislation's only been in effect since May 2016, so we don't have any real case law. A lot of the matters are still before the courts, and so it's not timely to weigh up the effectiveness of these of the legislation and the charges. That's it for the legislation there. It's work in progress as far as successes and failures in the courts. I'll move on to the National Domestic Violence Order Scheme, that's NDVOS. In December 2015, in December 2015, the Council of Australian Governments, that's COAG, they agreed to introduce a national DV order scheme to allow domestic violence order issued in one jurisdiction to be automatically recognised and enforced across Australia. All jurisdictions committed to introduce model laws to give effect to the NDVOS in the first half of 2016. Now, to support the early implementation of the model laws, the Law, Crime and Community Safety Council and the COAG agreed to the development of an interim technical solution, while a 4-year project to develop and deliver a national technical capability for DVOs, which will facilitate information sharing and enforcement of DVOs between courts and police across Australia. Now, the point to note with the national recognition of DVOs is that it doesn't introduce consistent DV laws. Each state and territory have got their own legislation, and the NDVOS, as the slide says, is not going to lead to any standardisation of conditions. Each case that a magistrate hears for an application for a protection order could have different conditions that are put on. Simple one, the standard ones of not to contact, not to approach. There may be other ones that, so they're not standardised across Australia. November 25th, 2017 was the legislative amendments to the DV legislation. And, sorry. So the how it actually happens is someone in Victoria, there's a domestic violence order taken out. The respondent is in court and is told the conditions of the domestic violence order. Now, if that the aggrieved travels to Queensland, for example, previously for that order to have any effect, she would have to go to the court and ask for the DV order to be recognised. From 25th of November 2017, that order is automatically a recognised interstate order. So the person travelling to Queensland is protected by that DV order, and if the respondent commits a breach against that, he can be punished under the Queensland legislation. The same occurs with a New Zealand, is classed as a foreign order. That will also be recognised as an interstate order once it's in Queensland. For the a contravention of an interstate order, there has to be proof for the court that the respondent was properly notified of the existence of the original order. It's not a defence in Queensland to say that he didn't know that the Victorian order was in effect in Queensland. There's no legislative provision that makes any the police or anyone have to notify him that the order is in Queensland. In actual fact, it's a safety provision too, that someone might want to relocate from another state. They don't want the respondent to know where they are. So it would defeat the purpose if the respondent got notified of the existence of that order being recognised in Queensland. Which is that slide there. The legislative change was only in November, so we haven't had too many incidences of contraventions. There's probably been about 22 reports regarding contravention of nationally recognised order, so we don't have any statistics on the results of those, of whether charges were actually preferred. They're just reports. There's between 25th of November 2017 and 31st of January 2018, there was 172 applications to declare existing DVOs under the scheme. So the marketing by the national body has seen the uptake of getting those orders recognised, giving the aggrieved a sense of protection. We'll wait for the questions on there after. I'll move on now to the police protection notice, which isn't part of the slide. Oh, sorry, one other thing. With the National DV Order Scheme, when a person is name checked, they check Australia-wide, also to see whether or not they have a license, a weapons license. Queensland, if you're subject of a domestic violence order, your weapons have to be surrendered. The same thing applies with interstate weapons license. The same thing will apply. So moving on to the police protection notice, I'll call it a PPN, and the original police protection notice was developed and issued in situations where police would attend a domestic incident and identify that DV had occurred, and rather than carting the respondent off to the watch house, it was deemed things had settled down enough that the person still needed to go to court, but could go under their own steam when a court date was set. So that protection order would say, protection notice would tell the respondent that he had to go to court and that he was not to commit any further acts of domestic violence. That form didn't get a lot of take-up, but since the Bryce report and the high profile of domestic violence, the police protection notice was revisited, and it's been reprinted, and certain amendments have been made to make it a much more workable document. The PPN has got it has three functions. It exists as a notice to appear, in the sense that the respondent is told that he has to attend court on the next available court date, and it also functions as a temporary protection order. Previously, if there were concerns for the safety of the aggrieved, police would have to ring up a magistrate and get a temporary order, and that could 2 o'clock in the morning or something like that. It's not the ideal time to be waking up a magistrate, and that created issues. The change to that situation is that the PPN has a number of conditions on it. The mandatory to be of good behaviour, but there is also a no contact condition, and a cool down condition, and an ouster condition. Now, a cool down condition could be for 24 hours, you're not allowed back home, so you technically cool down. A no contact, if the situation is determined that the respondent's not to contact for any reason, with the approval of a senior sergeant or above, the officer can put that condition on the respondent, and that condition is current until the matter is heard by a magistrate in court. In the more serious incidences, this would be where the respondent was probably taken to the watch house and processed. They're released on the PPN, and they can have an ouster condition, and the ouster condition says you are not going to that house until the matter is heard by the magistrate. So those for the police to be able to put those conditions subject to approval, on the scene, at the scene, or after an arrest has saved ringing magistrates in the middle of the night, but it's not giving police total power over the respondent. It's only until the matter is heard by the court, and then the magistrate will look at the grounds on that PPN, and the grounds will say the reasons why police attended, what they've found, and the reasons why they consider that person should not be allowed to return to the house or should not have any contact. And the magistrate, when they make the final order, may or may not agree with what the police on the night had decided conditions were applicable. So we have to make that very clear that the PPN is for immediate protection of the aggrieved, but it is really a transitional document in the grand scheme of things, because, as I said, it's a notice to appear in court, functions as a temporary protection order, and it is also the actual DV application for a protection order. Also included with the PPN is a named person adult and a named person child, and that means on that protection notice, if there's a new partner or parents, any other people that the respondent is likely to interfere with or harm, well, those people's names can be included on the notice, and also any children if there are concerns for their safety. And once again, once the magistrate hears the matter, they'll determine whether or not those people do or don't need to be on the protection order. Things do cool down. It could be at the time of the magistrate has the hearing. The aggrieved is quite happy to try and see if things will go on. The respondent's been remorseful, it's gone undertaken counselling already before even the court date, and it's the first one-off, no history. Well, then it might be the magistrate might say, well, yeah, okay, I'm making an order, but we're not going to have an ouster, we don't need it, or whatever the case may be. That's essentially it. I guess it's questions.
All right. Thanks so much. So we'll now turn to questions from the audience, and I'm sure you've got plenty of questions from that presentation. So there's already heaps coming through. So what we'll do is I'll just read through the questions, and then we'll throw it over to our special guests to hopefully be able to answer some of those questions. So the first question here is whether there are any statistics available on the rate of strangulation charges and the rates of conviction. So obviously strangulation has been in for a little bit longer than some of the other provisions that have just recently been introduced. Do either of you know whether they have been released by the QPS at this stage?
There are preliminary statistics, but we haven't released them at this stage. So they will probably have to request statistics from our unit if they would like them.
Okay, so hopefully everyone heard that. So if you do have a special interest in hearing about the charges and rates of conviction and some of the other stats around strangulation, you might be able to contact Christine at the High Risk Team, and she'll either be able to give you that information or put you in touch with someone who might be able to help. Thanks, Rachel. So the next question is, will orders before the legislation amendments passed be changed to be in line with the current legislation? So that's around the national DVOs.
From Michelle, yes. What's happened is any orders made from the 31st of May 2017 and up to the 25th or midnight 24th of November 2017, those orders, an application has to be made to have them declared nationally, recognised nationally. The Department of DJAG, Department of Justice and Attorney General courts have got a website, and they've got information there on the process of applying to have those orders recognised. Victoria actually is the only state that took the stance that they would retrospectively have all of their orders nationally declared. And that's about.
Okay, thank you. All right, so if we have a woman with a Queensland DVO and the perpetrator located in Victoria, if he sends her a text that is in contravention of a no contact order, will he be charged in Queensland or Victoria?
Well, the way it'll work, there's an agreed process where the Queensland woman would make a complaint to police. Police would get the evidence, which would be, say, a screenshot, whatever, and then that information will be sent through the appropriate channels for VicPol to then charge him, well, basically charge him with a contravention.
Okay, so Victoria would be so it's kind of...
But it would start in Queensland because she makes the complaint to the Queensland Police.
Yep.
And, so you won't have the Queensland Police going off to Victoria to track him down. But if it's established he's living in Victoria, and there's evidential issues, but if she's received on her phone or on her computer something that she knows can only have come from him, on the face of it, he's committed that breach. So that would screenshots and her statement would be forwarded through the appropriate contact points for Vic Police to follow that up. As far as proving he was the one that hit the keyboard, that's another issue altogether.
Sure, no problem. Do you think that might, or do you envisage that might result in any delays? Having to transfer between state police in Queensland to Victoria Police?
In that, there could be delays, but it's the safety aspect. He's in Victoria, she's in Queensland. So you're looking at the actual condemning the breach. So it's a natural delay as far as, it's electronic. So essentially it wouldn't be weeks and months.
So this one's also around time limits. So do you know how long between the service referral to the high risk team and the high risk team then engaging with the client? So referral from an agency into the HRT.
Yeah, so what happens with that, the HRT core members don't actually engage face-to-face with the client. So, for example, with the QPS, a high risk will be identified and then that will be referred immediately to the high risk team. So the high risk team will have a look at all of the information that they currently have. They may call around to other agencies and get a bit more information. And then a police officer would go out and speak to the client, or the high risk team would request that a DV service, for example, would go and speak to the client. So because it's high risk, they try and deal with the cases as they come in. There isn't a set time limit though. Also with the QPS is a little bit different because when the frontline officers attend the initial incident, police at the scene will actually refer a client to a support service as well. So they may already have engagement with the support service, but the high risk team will then still take on the case because they may need extra support services in place.
Okay, fantastic. So do the high risk teams share information across models, for example, between urban and regional?
Yeah, so with the high risk teams, there's a dedicated information sharing portal which all of the core agencies use. That portal is compartmented. So, for example, Logan Beamley can't see any of the cases that Mount Isa or Cherbourg have listed. In saying that, if a client was to move, for example, from Cherbourg to Logan or Beamley, the Cherbourg high risk team would then transfer the case across to Logan HRT, and then they would be able to see all of the relevant information.
Okay, good. So when the DVO application asks for different conditions to what is in the PPN, which conditions do the police intend to ask for? So Rachel at Women's Legal Service has said that they've found that different magistrates take different approaches, so it would be good to know what police are intending.
Yeah, good question. And from the police perspective, there's many police officers that have taken out the PPN, and when they follow up the following week, they find that conditions that they put on the PPN aren't reflected in the order. Once again, it's the conditions that are put on the PPN are done at the time to ensure immediate safety for the aggrieved. And generally the police prosecutor who's mentioning the PPN in the magistrate's court would be across those conditions and would be articulating the need for those conditions to continue. You've said it right there, different magistrates take different approaches, and the police aren't able to necessarily override a magistrate's decision. If they've had time to speak with the aggrieved, and the aggrieved is adamant that certain conditions are necessary, generally my experience is the magistrate will give the aggrieved the opportunity to address them in court, or the prosecutor would address on the aggrieved's behalf to explain why the conditions are necessary. I hope that answers that one.
All right, thank you. So still a few questions coming through. Thank you for sending them through, and please do keep typing them in, and we'll try and make sure we get to all of them. We've still got plenty of time. So this one's from Jonathan. Are there any other ways that the victim can access assistance from the QPS other than having to attend the police station? Because a lot of the time it's just not convenient, or sometimes even possible for them to do so.
So if the victim hasn't approached QPS initially, they are able to go through PoliceLink for non-urgent matters, and PoliceLink can provide assistance to a victim. Alternatively, if the QPS has already attended the scene and spoken with the victim initially, they may be able to identify convenient times for a police officer in plain clothes or a DV coordinator to go back out and speak to the victim at a safe time for them. Otherwise, on the QPS public internet site, there are a number of support services listed, including telephone numbers that a victim might be able to use to contact someone for assistance.
So within the police, or are they external agencies like DV services?
Yeah, so some of them will be DV services, yeah.
Okay. Good.
And the courts for private applications for protection order, the courts have got on their website, they've got information there.
And certainly that's what a lot of our members would be doing as well, potentially, private applications. Okay. So are there any similar provisions in relation to orders made in New Zealand, or where a party is residing in New Zealand? Now, you did mention New Zealand. Do you want to go over that a little bit more, maybe?
Well, the legislation only provides that the only foreign orders are a New Zealand order that is registered in Queensland. That'll be recognised. Once it's registered in Queensland, that would be recognised nationally. As far as enforcement of breaches, you've got the same the setup. Basically, wherever the jurisdiction is where the respondent is located in relation to a contravention offence, that jurisdiction is responsible for the prosecution. Like I said before, if the report comes in from Queensland, obviously Queensland would provide the Victorian police with the evidence from Queensland, rather than just say, oh no, you got to make a complaint to the Victorian. So there isn't anything locked in with New Zealand at the moment, but New Zealand are looking at strangulation legislation and looking at reciprocal arrangements for DV.
Well, that certainly would be welcome, I think.
Yeah.
Yeah. So following on from that, what then is the process to register a New Zealand order here?
I don't know.
Oh, so would that be going to the court?
The courts,
yeah.
It would be on the website there. It's the same as when making an application to having an order recognised, an existing order recognised.
And so just to clarify, New Zealand orders are not part of this scheme where it's automatically recognised. It must be registered.
Yes.
Is that right? Yeah. Okay. All right, thank you for those. So Paul's asked a question for the high risk team. What is the anticipated turnaround of exchange between agencies? I guess regarding the information sharing provisions.
Yeah, so with the high risk teams, there isn't any particular timing around provision of information. Rather, what happens is they'll have a high risk client, say for example, Queensland Health request information from QPS. QPS will provide that information, so they'll try and provide it the same day. Normally what happens, a client will be referred to the high risk team. That case will be discussed that week. And then also there's provisions for like emergent meetings. So if, for example, a perpetrator is released from prison early, probation and parole request an emergent meeting to say, you know, the date of the release has changed. We need to, I guess, move up the safety management around the victim. So they have facilities to be able to hold a meeting like instantly. So if they can call all of the agencies together and then they'll all discuss the case and put more provisions in place to protect the victim.
And another question here around the definition of in a timely manner. That's one of those catch-alls.
Use your imagination there, Paul. Obviously, because they're dealing with high risk, they will try and get the information out as soon as possible. But of course, it would depend on how many databases, for example, they would have to troll through to get the information, how many people they might need to speak to regarding an incident. You know, there's a lot of different variables involved. And also because the information has to be relevant to the case and to the safety around the victim. So they would also need to go through the information first to ensure that it is relevant, because obviously there's a lot of data held by different agencies and we don't just want a lot of information to be provided because one, it might not be relevant, two, it would take a lot of time to sift through non-relevant information, and three, providing a whole heap of information would probably put a victim at risk. So unfortunately no time frames, but as soon as possible.
All right, thank you so much. I think that seems to be all of the questions for today. So if you've got any last minute burning questions, please do type them into the box now. I see that one person has their hand up. So Olivia, I'm just going to double check. Did you want to ask a question verbally, or if you would like to ask your question, you can just type it into the chat box. Similarly, Rachel, have you got a question that you'd like to ask? I can unmute you if you've got a microphone accessible. Okay, thank you. And I haven't heard from Olivia, but Olivia, if you do have a question, you can certainly type it into the question box. For anyone else who would like to go away and read through the materials, if you've got follow-up questions, please email them to me and I can pass them on to the high risk team. Thanks so much, everyone, for attending today and for your excellent questions and involvement there. Just got one last question, so I think there's time to deal with that from Jonathan. So is there any way to seek or request a time for the time frame to be expedited with the high risk team, particularly for regional victims?
So what happens with the regional, for the areas with a high risk team, all of the relevant agencies are already sitting at the table. So they all work collaboratively together. A lot of the teams co-locate as well, so they can just turn to the person next to them from the other agency and say, you know, we need this information. The high-risk teams aren't designed for people outside of the high-risk areas to be referred in. in those instances, then the police, for example, would fall to their integrated service response, which is where they engage with other agencies on a regular basis.
Okay, thank you.
Yes.
So just a last question here. Nice quick answer there. So can national DVOs be varied in a state other than the one it was made in? So if we've got a DVO made in Victoria, can they seek a variation in Queensland?
Yes, that'd be via the courts.
So the usual processes for a variation.
That's right.
All right, fantastic. Okay, I think we'll probably wrap up now. So thank you so much to our guests, Sean and Christine, for attending today and for taking you through what is going to hopefully be a promising suite of legislative changes in the DV area. Thanks everyone for listening, and on behalf of everyone wildly clapping and cheering at their computer screens, thanks again for attending and for sharing your expertise with us today. I'll finish up the webinar now, and just a reminder that it will be recorded and we'll pop it up online this afternoon or tomorrow morning. Thanks everyone.
Bye.